Okay, so to speak on this matter, Mr. John Matthew, a legal practitioner, thank you for coming on this morning.
Thank you.
I mean, you have people who have said, several letters out there about if that first process has been concluded and the governor acquitted, if we could use that word, why are they going up again to see if they will continue that impeachment? Some have consistently said that that has no basis in law. Is that correct?
Well, first and foremost, let me say that it would be wrong to say that the earlier process has even been concluded. The provisions of Section 188 of the Constitution, which guides the removal of governor or deputy, is quite explicit. It begins in the House of Assembly and ends in the House of Assembly. The panel that sat had an obligation under Section 188, sub 7b, to submit a report of its findings to the House of Assembly, not to anybody else. Not the way they went about it, as if they were a court of law, making a finding and taking a decision with a gavel. The section requires that their findings, the findings of their investigation, should be submitted to the Speaker of the House of Assembly. If their conclusion was what they reached on the 5th of August, I can tell you without any doubt that such a report has yet to be taken to the State House of Assembly. So to say that such a process had reached its conclusion cannot be correct.
Is that to suggest that if they are such that the governor was free to go, that they couldn't prove anything?
Yes.
Does that mean that if they submit that same finding to the State House of Assembly,
yes,
was the content or was the finding going to change, or was it going to be invalidated?
Absolutely not. The Constitution is also very clear about that. If the finding is that none of the allegations has been established, the matter ends there. If they find that any of the allegations has been proved, then the House of Assembly has 14 days within which to take a decision, one way or the other, either to act upon the finding by carrying the process to a conclusive end, or to, in fact, refuse to go beyond that. But once it is shown by the report that none of the allegations has been established, the matter ends there. But what I'm saying is, when you don't have a report submitted to the House in accordance with the provisions of the Constitution, then there was no report.
Irrespective of the finding?
Yes, irrespective of the finding. They had a duty not to make a finding. Of course, if they wanted to announce to the entire world their finding, they were well and good, but they still had a duty to submit a report.
Are you
and that's why I'm saying
that report has not been submitted?
It's not been submitted. I can tell you that with certainty. I'm counsel to the State House of Assembly. I will know.
So what's the guarantee that if the report was submitted, the legislators would have looked at it at all, considering that they were already at war's path with the panel?
You see, the point is this. The position of the legislators have been very, very clear right from the constitution of the panel. If you look at Section 188 sub 7A of the Constitution, the powers the panel can exercise can only come from one source, that is the State House of Assembly. The rules of procedure can also only come from one source, that is the State House of Assembly. That's not what this panel did.
What did they do?
They drafted the rules themselves, gave themselves the powers they were exercising, and went ahead to sit the way they did. Now, let's assume that no such rules or powers were enumerated. What were they supposed to have done in such a situation? They ought to have written to the Assembly. Law says, empanel us. We've been empaneled. Even with the reservations, can you give us the powers and the procedure we have to follow? That wasn't done. So, ab initio, the entire proceedings of the panel was a complete negation of the provisions of the Constitution. They had no such powers to have empowered themselves and made the rules of procedure upon which they sat and came to the conclusions they came on the 5th of August. So, the position must be made very, very clear. Apart from the reservations that were expressed about the membership of the panel, of course, the panel cannot, apart from a moral duty when you are accused of something, you want to step aside to ensure that the thing is established. Apart from that, they had no legal duty on themselves to have disqualified themselves. But then the person who appointed them, the CJ, if he didn't know about the legal disabilities they suffered, then he was at least informed. When the House made a resolution giving evidential proof of the disabilities of the membership of the panel, he also was reminded, the resolution was on the 30th of July, by the way. He was also reminded by a follow-up later on the 4th of August that, look, you have not responded to our observations about this panelist. And the observations were predicated upon a complaint that was generated and sent to the House by 2 members who signed a petition saying that, look, we know as a fact that Mr. Sabo Kiana is a member of the People's Democratic Party in Amiri Ward of Kiana Local Council and was, by virtue of the provisions of Section 188 sub 5, ineligible to serve in the panel, being a member of a political party. They quoted his registration number and annexed to the letter membership register for that ward.
But who proves that he's ineligible to be in that panel?
The point is, if item 1, 2, 3 are the criteria upon which you are supposed to be imbued with to serve on the panel, and I have information that item B disqualifies you, I have a duty to come forward.
I get the point.
Yes.
If a section has been violated,
yes,
are you not supposed to seek redress?
Yes. But
So?
again, let us look at it this way. The CJ has the statutory powers to make the appointment, pursuant to a request by the Speaker.
Which he did.
Which he did. If he had a duty to make the appointment, and the duty is not absolute, the discretion given to him there is not absolute. The appointment, yes, in his opinion, members who are of unquestionable integrity. But here is the snag. You must not belong to a political party. You must not be in public service.
If that is violated or flouted,
yes, if
what
it is
happens?
flouted, and granted that perhaps the CJ did not know of these disabilities in the members, he has now been alerted.
So if you
have the powers to appoint, it comes with it with a responsibility.
What if he
fire.
then says, to the best of my knowledge, all that I have appointed are within the rights to be there?
That is the point. The man has not said, sorry if I may use, if I'm using that word wrongly, the Honorable CJ did not even respond to these allegations. He did not draw the attention of the membership of the panel to the disabilities that are being alleged against them.
So
can you react, just a minute, can you react, they say you are a member of a political party, what's your reaction to this? They say you are this, what's your reaction to this? He has not done that. He has not even responded to these official communications by an arm of government saying that, look, this panel you have appointed is in violation of this. And I beg to disagree with those who argue that once the CJ makes the appointment, that he becomes functus officio.
So isn't
if a member, let me give you an example. If a member of the panel were to die or were to resign, are you saying that the panel collapses, that the CJ who made the appointment could not make a replacement?
Yeah, but Mr. Matthew, if
yes.
there's a dispute about the matter,
yes.
which is what it is, I believe, what it is now,
yes.
where is the right place to seek redress?
First and foremost, are you talking about a dispute prior to the conclusion of the assignment, or a dispute now that has arisen with respect to the petitions to...
You say there's a dispute prior, but you say there's also a dispute in the constitution of that panel, which it not responded to. And there are lots of people who have said, okay, fine, the way it is this. Yes, Section 188 sub 5.
Yes.
He's got the powers. Yes. He set it up. Yes. Now you say he was notified. He didn't even respond.
Yes.
And so perhaps he must have felt that he's in the clear and that he's in the right to go on with the way he is. And you feel, no, that's not right. He can't do that. Where is the appropriate place to seek redress?
Isn't it proper? You see, okay, I know where you're going to. Some have argued in some quarters that the House needed to have gone to court, the House needed to have done this, the House needed to have done this. If you were, in making the appointment, the CJ did not know that these members suffered from these disabilities, the first point you will ask is that, how then, what then does he know about them, the people he appointed? If on the other hand, they were recommended to him, and he now discovers, because these allegations were not made bare, they were made and substantiated with documents. Here is the membership register for Amiri Ward in Kiana Local Council, with Mr. Sabo Kiana as the number 2 person registered in the ward. Here is the membership register for this other ward in the Kefi local council with Mr. Abdullahi Usman Galadima registered there. And here is an appointee of the governor who is a serving member in the Pilgrims Welfare Board with proof that he collected salaries or allowances in June, just a month prior to his appointment to serve in that panel. These are hard facts. Should the CJ close his eyes and say, well, I have done the appointment, but you can go to court, which is what he has done, and which is why the House disagrees with the position he has acted, that it's apparent that there were other interests other than, in making the appointments. And therefore, let's not forget this. The National Judicial Council has supervisory and disciplinary powers over judicial officers. If you look at the third schedule, part 1, you will discover that they have the powers. And so, if you have options in dealing with a particular issue, either you go to court or you apply to a disciplinary body.
So they chose to apply rather than go to court?
Yes, they chose to apply. They had the options. They had the options to go to the NJC and say, look, the Honorable Chief Judge of Nasarawa State made these appointments. He had the powers to do, which he had the powers to do. But in doing so, he had violated these provisions of the Constitution. And we brought this to his attention